Before we start today's function, uh, I have to tell you, because it's probably my last day, I have to tell you, you've been a fantastic crowd so far. It's always a pleasure for any speaker to stand before a crowd which is very receptive and very responsive. And I'll tell you, by far, this is the best crowd I have seen for any speaker to stand before. So I would thank you all for that deeply. Having said that, our first speaker, and before I get to the first speaker for today, this is probably one of those rare occasions in the history of CLEP where you have three out of the four speakers who are the former chairmen of the State Bar Council of Maharashtra and Goa, including our first speaker for today. He needs no introduction. He completed his LLB from ILS Law College, Pune. He has been practicing as a lawyer from 1977. He was a part-time lecturer at ILS till 2008 and thereafter has been a visiting faculty. He has been a member of the governing council of ILS Law College. He practices at Pune District Court on matters both pertaining to civil as well as criminal. He has conducted several election petitions at the Bombay High Court. He's also involved actively in arbitration matters. He is our former chairman of the State Bar Council of Maharashtra and Goa. Ladies and gentlemen, may I introduce to you our first speaker for today, Mr. Shrikant Kanitkar. Please give him a big hand. May I now request our member and former vice chairman, Mr. Anil Govardipe, to give bouquet as well as memento for CLEP 5 to our first speaker for today. Mr. Kanitkar will be talking to you on drafting, pleadings, and notice in civil suits.
Friends, we'll start with notice. For the simple reason, one may say, what is the connection between notice and pleading? Apparently may not be. But if we see deeply, there is a connection between notice and pleading. And how and the importance of notices we'll take into consideration. And moreover, when I am told that, well, this clip is, as usual, is for the junior members of the bar, the notice becomes very important. The least a junior can expect in the junior days is at least notice, because I have gone through project phase Everybody has to go. You may not get it in initial stages, the big clients, but you can get some clients at least for coming to for issuing notices. Friends, notices are taken very lightly by the, sorry to say, by the lawyers. I will give certain examples, and which may create havoc when we go to the court of law on the basis of a wrong notice. Friends, when we talk about a notice, what is the meaning of a notice in common parlance? And then we'll go to the consideration of the law. In common parlance, when we talk about a notice, is nothing but just given information to the other side or entire general public at large. In legal, same, little bit difference. It may be a sort of a warning to the general public or a people. We are the student of law. Suppose you are passing certain grounds or you are going from the road, so big bungalows, you find that, well, stick no bills. What is the meaning of it? Stick no bills. Krupaya jaherati lau naka. Don't cross this particular bungalow or a particular private road. Trespassers will be prosecuted. What is the meaning of it? It's nothing but a notice giving a warning. Even saying that, well, be aware of dog. We see that, well, there may be a privileged dog. You know what is a tort. In tort, that may be one of the grounds for filing a suit for particular damages. What the owner is doing, he is putting a warning to the entire public at large that I have kept a dog which is ferocious, and therefore be aware of the dog. Sometimes you are crossing the roads, highways, work is going on, work in progress. What is the meaning of it? It's nothing but a notice. Don't park your car within 50 kilometers. What is this? Is a notice. Just like, my friends, in a contract, what we always talk, if you enter in a bus or a railway or even a cinema theater, you buy a ticket. What is that exactly? You buy a ticket from a bus conductor. It's nothing but a contract, maybe for 10-15 minutes. But it's a small species of a contract. That means you say that, well, you pay for it, that is a consideration. Along with you give a proposal that will allow me to enter into the bus, and it takes you to the destination. It's a sort of a contract. See, law has to be understood, my friends, from all these small matters. So therefore, when we talk about a notice, now I just gave the examples regarding what is meant by notice in common parlance. The same is the meaning, practically the same meaning in law. What do we do by giving a notice? When we will consider several types of notices, what do we do in notices? We bring the facts to the knowledge or notice of the other side. For example, in a petition to be filed for restitution of conjugal rights, you issue a notice. What is the purpose of it? Whether law requires it? Law doesn't require that notice must be given. But you give a notice. What is the intention? Intention is both positive and negative. You give a notice to the other side, just bringing the facts to knowledge that, yes, your behavior is wrong. And therefore, please correct your behavior. You come to me. You come and cohabit with me. If you do not, I will have to file a petition, maybe for restitution of conjugal right under Section 9 of the Hindu Marriage Act, or it may lead to a particular petition for a divorce under Section 13 of the Hindu Marriage Act. It's a sort of a warning. So you bring to the facts to the knowledge of the other side. Then you will come to know that, well, how when I say that the notice has a connection, a great connection with the pleading. Notice itself is not pleading, my friends. Notice itself is not pleading, but it has connection with the pleading. I will cover this in my particular, during the course of my lecture. So friends, therefore, this is what for, you give a notice under Section 80 if you want to file a suit against the government. What is that? You just give a notice to the government that, well, yes, this is the wrong which has been committed by your officer. Therefore, try to correct it. You give him a period of 2 months, you wait it. Because law requires you to wait it. And then, if no positive action has been taken by the government, you go in the court of law. This is what a notice means, bringing the facts to the knowledge of the other side, making the other side aware that, well, yes, legal action is going to be taken in that case. This is the meaning of a notice, my friends. And if we consider, my friends, you will not get any particular book which will say that these are types of notices or different. But from practice we can very well say that there are several types of notices which, as a student of law, I always say, I never say lawyer. Because every lawyer is a student of law. I am also still a student of law. Because the law is such a vast, my friend, that nobody can boast it that, well, I am complete in everything, nothing doing. I am practicing at civil side for last 36 years. Still I say, if I have to draft a particular complaint, still I say, what facts I must cover. When I will give an example while considering the drafting and pleading, that time I will tell you. You must be always aware of substantive law. And that is why, and when I tell substantive law means also the latest judicial decisions. I will give examples to you and how it makes difference when you are drafting a particular plaint or you are drafting a written statement, my friends. Let us see, my friends, what are the types of notices and the effects of it. Friends, when we talk about the notices, I told you the general importance in common parlance in law, and let us see. According to me, the 5-6 types of notices broadly I am talking about, which a student of law must know it and keep in mind. And the first is a statutory notice. Why I call it a statutory notice? When I will give you an example, if you will understand. Statutory notice means a particular statute prescribes it, or particular statute provides it. The effect is, if that statutory notice has not been given, your action may not be maintainable, your suit may not be maintainable, barring few exceptions here and there. Let us take an example when we say that, well, just now I told you, if the suit is to be filed against the government, wording of section 18, no suit shall lie. It starts with non-obstinate clause, no suit shall lie. If the suit is to be filed against the state government or any officer, say state or central government against any officer or any other particular person. Now, if friends, therefore, complying the requirements under section 80 is a must. It's a condition precedent. Means what? That if you do not give notice, your suit itself may not be maintainable. It has got both positive and negative aspect. For example, in a positive, which is very unlikely, my friends, but still we can keep the hopes. If you give a notice to the government or a government officer, they may correct their things and you may not require to go in the court of law. In fact, that is the intention, keeping the 2 months, giving a notice to the government before filing a suit. For example, I remember a case wherein a property was leased out by the collector to a particular society. Several terms and conditions were there, and without complying those terms and conditions, the Tahsildar, on behalf of the collector, issued a notice saying that they are taking the possession within a period of 8 days from the receipt of the notice. The people came to me. I issued a notice under section 80, contending that, well, that you can't take the possession without following a due process of law. Please go to this particular clause number so and so. And particularly when the lease has not been terminated. He communicated that, yes, we'll take proper action. No action was. We are not required to file a suit. Friends, therefore, it is a positive act. But in very rare cases it happens. Generally, if you issue notice under section 80, you know that, well, even that the concerned officer may not be even aware also that well. But, see the negative part of it. If you do not give a notice under section 80, unless there is a case you are coming under exception of section 80, subsection 2, your suit is not maintainable.
Law provides it that well, no suit shall pass, no suit shall lie unless notice is given. So therefore, action can be taken under Order 7, Rule 11 of the CPC. You know what is meant by Order 7, Rule 11 of the CPC. That is the rejection of the claim. If you see Order 7, Rule 11, subclause D, which says that the plaintiff suit is barred by any provisions of the law. Any provisions of the law. Law prohibits for filing a suit against the government without issuing a notice. State-wise particular application can be filed saying that, well, you have not complied with the provisions of Section 80, therefore suit is not maintainable. Suit is liable to be dismissed under Order 7, Rule 11, subclause D. Plaintiff can be rejected in that case. Liable to be rejected. That is the negative aspect. Therefore, we say it's a statutory notice. It is a mandate given by the Civil Procedure Code that no suit shall lie against the government. So therefore, you are required to take into consideration that when such a statutory notice, which we call as a condition precedent. So it has to be given in that case. And I told you, barring exception of subsection 2. Where subsection 2 of Section 80 now, after the amendment of 1976 Civil Procedure Code, it says that, well, in urgent matters, you can file a suit with the leave of the court. So again, in that case, you are required to leave of the court. That you must be aware of it. And if you do not take the leave of the court, under Section 80, subsection 2 of that Act, again your suit is not maintainable. So therefore, you have to make separate application in a suit, along with the suit, that will allow me to present the complaint, allow me to file the suit in that case without receiving a notice, grant me a leave. That application will be heard by the principal judge. And if the principal judge feels that, well, yes, it is not practicable to give a notice considering the relief. For example, the example which I gave, I could have filed a suit without giving a notice, but I say that, well, let us see. And in between, if they still threat continues to take the possession, I would have filed a suit. Because if I wait 2 months, by that time they would have taken the possession. So in such a cases, I can make an application that will grant me a leave, that is leave to file a suit without issuing a notice. And that provision is there. Earlier that was not there, but it has been introduced in 1976 when the Civil Procedure Code was amended in that provision. So therefore, this is what we talk about, sir. Let us take an example, another that well, those who were the students who have conducted these particular matters under the Mahata Rain Control Act. You must have come across Section 15 into bracket 2 of the Mahata Rain Control Act. What it says, no suit shall lie in case of a particular default against the tenant on the ground of default. What does it mean? And you are required to wait for a period of 90 days. What is the meaning of this type of a notice? This notice is nothing but a statutory notice. The effect is, wording is again, no suit shall lie. If you file a suit against the tenant on the ground of default without issuing him a demand notice, then your suit itself is not maintainable. Not only that, you are required to wait for a period of 90 days. That is the provision. It's a statutory notice. So therefore, when we talk about various types of notices, for example, those who have considered this Bombay Provincial Municipal Corporation Act, Section 487 contemplates that no suit shall lie against the corporation unless notice, like Section 80, 2 months notice has been given. So these are all called, as my friend, statutory notices. I term these as particular statutory notice, mandatory notice, where the law requires the mandatory provision to give a notice in that case. Then that will take me, my friends, second type of notice is contractual notice. What is meant by a contractual notice? The parties themselves agree in a particular cases to issue a notice, and you will consider, my friends, and you will come across non-giving of any issues or non-issuance of a notice may become fatal because the parties themselves have agreed to give a notice. For example, in a live-in license, lessor and lessee, they say that, suppose, you know that well, lease can come to an end under Section 111 of the Transfer of Property Act. What we talk about the forfeiture of the lease. Lease may come to an end by termination of a lease, provided there is a forfeiture clause. This is not the today's subject, but I am just Nothing I am telling you that way. And therefore, in that particular case, by contract itself, because it's a contract, lease is also what? Lease means contract plus conveyance. Because ultimately some property has been transferred in case of a lease. So first there is a contract and then there is a transfer of property. Contractually, every party has bound themselves to issue a notice, or if the lease is to be renewed, option to renewal is given to the lessee or a lessor. Again it contemplates, if the lessee wants to, but transfer of property does not contemplate this type of a notice, but parties agree. So though it is called as a, therefore it is a contractual notice, but to some extent or to what extent, what some can say, it is becomes a binding between the parties. Lessee, in spite of this, if notice is not given, the lessee can take a stand in the defense in the written statement saying that, well, suit is bad in law. Notice of termination has not been given. Lease is not terminated by expiry of the 3 months notice. He can very well take the defense. And you will find that the cases have been decided on this particular point that, well, possession suit was not maintainable in that notice. So therefore, even though it is a contractual notice, it will be also binding because the parties themselves have agreed that well. Suppose the partnership is at a will. You know partnership law. And one of the concepts is know that well, a house partnership can be determined. One of the modes is that well, partnership at will. What is meant by partnership at will?
At will, notice is mandatory. But if that 7 days notice has not been complied with, that 7 days can be contemplated in the case of a summons of filing up a plaint for dissolution of the partnership. But again, the apex court has held that the notice is necessary. So it's a contractual notice, my friends. In case of arbitration, in case of leave and license, in several cases, my friends, you will come across where parties themselves agree, stating that well, particular period of notice is contemplated to be issued by the other side, so that certain actions can be taken in that case. I call it as a contractual notice. The third notice you might have come across, third type of a notice is a public notice. What is this concept of a public notice? You must have come across. The public notice in some cases given as a precaution. In some cases it is given as a necessity. I will give the example, then you will understand it. As a legal necessity, in some cases it is binding. And in some cases you give as a precaution, as a warning. I will explain all these 3 aspects. As a precaution, what we do? Those who have been doing this exclusively conveyance, and even to some extent they have considered certain conveyance part of it, if the sale deed is to be executed, some mortgage deed is to be executed, that is transfer of property, notice is given. मराठीमध्ये आपण म्हणतो, आमचे क्लायंटनी विकाव्यास काढलेली आहे, त्याच्यावर कोणाचा, आपण म्हणतो ना त्याच्यामध्ये पोडगीचा, चोळी बांगडी, अमुक सगळं आपण शब्द वापरतो त्याच्यामध्ये. कोणाचा जर हक्क असेल तर तो आम्हाला कागद देऊन साबित करावा. This is a notice in a sort of a precautionary notice. Just to test the title. If a purchaser comes to you, he says that, well, yes, vendor, I have already seen your document, but still I want to get it because in some cases matter may, for example, some cases suit may be pending, in some cases some transaction might have been entered into. So in such cases, therefore, we give a public notice which is a precautionary measure. Law does not contemplate, law does not take away also right. But in one case, it has been held, particularly in Maharashtra Ownership Act, those who are the persons who have conducted the matters under the Maharashtra Ownership Act, what we call as a MOFA. There is one judgment about Bombay High Court which says, sir, that well, Justice Dhanuka has stated, Senior Dhanuka, he has stated in that case that a notice under the MOFA, Maharashtra Ownership Act, for search, title, etc. is a must. That is what he has taken the view. So friends, what I was contemplating that, well, in some cases it may be precautionary. But for example, my friends, when I say it is necessary also. Suppose you are terminating any document. Take example, your client has given a power of attorney to the other person. You know what is mean by power of attorney? Giving several rights to that particular person to negotiate, enter into an agreement, sell, accept consideration. Several powers have been given. And that power of attorney go on doing. What is the relation created? That power of attorney holder is your agent and your client is the principal. Now, in law, what is the meaning of it? The act of agent is the act of principal. So whatever that power of attorney holder does is binding on the principal so long as the power of attorney is still in continuation. If you see, my friends, Section 7 of the Transfer of Property Act, who can transfer the property? Section 7 says, transferor, major, etc., of himself, or he can transfer the property not of his own, legally authorized. So power of attorney holder, property doesn't belong to him, but he has a right to transfer the property as per Section 7 of the Transfer of Property Act. Under what provision? Because there is a relationship of principal and agent. So agent can bind the principal provided he act within the four corners of that power of attorney. But so long as that power of attorney is there, he can always particularly exercise those rights. Suppose some dispute starts, or the principal, that is your client, comes to know that the agent is misusing his powers. Then in that particular case, the principal can terminate the power of, that is the agency. But so far the entire world at large, how they will know that you have terminated the power of attorney? How he will know? So therefore, if your client has terminated the power of attorney, it's better way to make it public, saying that, well, we are cautioning the public that my client had given a power of attorney, but it stands terminated with effect from so and so. Nobody should enter into any transaction with him. And if he enters into any transaction, that will be totally illegal. I'm not binding on my client. This becomes a necessary. But take example in case of partners. Partnership firm has been dissolved. What is the relationship between the partners according to the Indian Partnership Act? If we see the definition of Section 4 of the Indian Partnership Act and the express and implied authority under Section 18 and 19 of the Indian Partnership Act, what is that? Well, when they are acting within themselves per se, they are principals. But one partner is acting on behalf of other partners, then he is the agent of the firm as well as agent of the partners, other partners. If you see the definition of the Section 4, the importance of the partnership firm is that, well, firm comes into being by agreement for earning the profits, and every partner has a right to act on behalf of the other partners. That distinguishes the partnership firm business from other businesses. If you see the case law under Section 4, Section 5, we will come to know. For our purposes, my friends, if ultimately the partnership firm is dissolved, suppose the partnership firm is doing a business of selling the cloths, ready-made garments, saris, etc. Every partner has a right to purchase the material. Every partner has a right to issue the checks, has to do the trading, non-trading, everything. If the firm is dissolved and notice has not been given, what will happen? That partner may go on purchasing the property. And if ultimately the firm says that, well, firm is already dissolved, what that other product trader would say, we are least concerned. Have you published it that a firm has been dissolved? We acted bona fide, and therefore we are not aware that he was not a partner. That act, as per the judicial decision, is still binding on the partnership firm and all the partners, my friends. So it is always desirable that the firm is dissolved, better to give a notice, and even law also contemplates. Then in that case, public notice is to be given. The public notice is generally given in the local newspaper or a newspaper which is widely circulated in that place, which is also one of the mode of serving the summons also on the parties according to the law. If you see the provisions of Order 5, Rule 20, Civil Procedure Code. So therefore, my friend, this public notice sometimes precautionary, necessary, and advisable, desirable. In some cases, you must have come across. So long as the son is minor, all his acts, as we talk in tort, vicarious liability. You must have come across in the tort. What is mean by vicarious liability? But moment the son becomes a major, his acts may not be binding. But sometimes what happens, son go on taking the loans, go on spending the amounts, saying that, well, recover my from father. Recover my from father. And father, afraid of his reputation, etc.,